Dear Ms. Larry Fitzgerald Williams.
Yeah.
And this is cause number 25 DCCR 0985 and 24 DCCR 1790. And where are we on this? What is the announcement?
Well, Your Honor, we would like to put some pre-trial publicity that this case had last week, along with some pre-trial publicity early on in the case. We're going to be putting together a motion to change the venue, and I need about we want to have a hearing, and I'll just discuss this with the ADA about having a hearing in about 3 or 4 weeks on a motion to change the venue.
Okay.
Because they had a thing with Abbott last week that I think negatively impacted Mr. Williams in his case, and that we need to put together this motion to change venue because of the severity of this charge.
So I will I'll just do a normal reset, which
Yes.
is about 30 days.
Yes, ma'am.
If you'll get that filed, once that's filed, I would anticipate how long for that hearing to take place. How many, you would have a couple of witnesses, I would assume.
Yes, ma'am.
Mr. Smith,
I think it could be done in the morning, Judge.
in an hour or so in the morning.
Yes, ma'am.
So what we'll do is set it, well, it's going to be set at normal time until we get that motion.
Yes, ma'am.
Once the motion, we'll keep it on that day, and let's just make it at 11 o'clock on that day. But that way I need to make sure, or I need you to make sure and get that motion
It'll be
filed, and that way we'll do it at 11 o'clock on
Yes,
the next court date.
Yes, ma'am.
Okay?
Yeah,
Yes.
in reference to my case, I filed a motion for discovery. It's been partially satisfied, but the medical records, if you go on the discovery page, have not been scanned. And what I want to do is file a motion specifically for the medical records to be given to me as a PDF file, not a TIF file. Sometimes they do.
Why don't you get with Mr. Smith? If Mr. Smith refuses to do that, then let me know and I'll get involved. But if y'all talk, I'm sure if you also could probably get a thumb drive and they can download it that way, I'm sure they'll accommodate whatever you need. But get with Mr. Smith. If for some reason there's some things that you think you're not getting that you've talked to him about, let me know and we'll take care of that at
And so I'll be required in the 30 days reset for him. I'll make that the same appearance.
I mean, if you're going to join in that motion, I mean, we're not
But
going to, I would,
that's a separate case, so I'm not going to.
Yeah.
Motion.
I think it would primarily be with regard to the capital murder case and
Sure.
not yours. So I would think, let's see, we'll go forward. I would assume Mr. Smith is going to want to go forward with the capital murder first.
Absolutely.
Okay.
So
Well, I'd rather, if we need them both here, I don't want them to have to transport defendant twice.
Right.
But for the next hearing, if that motion's filed, the primary purpose of that motion will be for the change of
Yes.
venue, and you will.
Right out of the gate we're dealing with two separate cause numbers, and that already tells you this isn't a simple one-case situation. When a defense team starts talking about changing venue, that means they believe publicity has poisoned the jury pool. Question for you: do you think media coverage can really make a fair trial impossible?
It won't be necessary for you to be here.
and so
We'll give you notice of it. But if you just want to call and talk to Ms. Holmes and make sure what it's set for.
and they'll email me a new setting for him in reference to the 24 case.
I'm going to keep the cases together.
Yes.
Just because that's easier.
Okay.
I'm not going to have Mr. Williams coming one day on transport
Right.
for Mr. Cash and one day for you. I'm going to keep the cases together. For the next hearing, I'm telling you, you're going to get a notice of it,
Right.
but you don't have to be here.
And then
We'll take care of Mr. Cash's motion. Then we'll see where we get after that.
okay.
Yeah.
Okay?
I'll send him a thumb drive.
Yeah, this is the first I've heard of an issue with the.
Well,
Okay.
I
Just, yeah, give them a call. Just, y'all work that out the best you can, outside of court. And if there's any issues, then let me know and we'll handle it here. Okay?
Thank you.
Thank you.
Thank you, Judge.
Yes, sir. See, is Ms. DeLage here? Yes. Good morning. On Heriberto Chavez. Good morning.
Good morning. We also have translator.
Okay, good morning, Ms. Burks. How are you?
Good, how are you?
Please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Thank you, ma'am. Good morning. Are you Heriberto Chavez?
Yes, ma'am. Yes.
And this is 25 DCCR 0559. Mr. Chavez is charged with deadly conduct, discharging a firearm. And what is the announcement?
We are going to ask for a reset, Judge. I'm kind of new to this case. He was at the Jefferson County Jail and then moved to LaSalle, and we didn't realize it. So there was, anyways, got to meet with him, but need to go through the media.
Sure. Okay.
And Ms. DeLay just approached me about changing my offer. I told her I don't see myself doing that on this case. So we'll just need to make sure she has all the discovery she needs so she can go with it.
And so what I'll do, Mr. Chavez, is reset your case for about 30 days. And that'll give Ms. DeLay time to come visit.
When they mention Abbott, that likely refers to Texas Governor Greg Abbott if a high-profile political figure publicly comments on a case that can absolutely fuel a change of venue argument. The defense is signaling our client can't get an impartial jury here, but hey, race the twist, judges don't grant these motions easily. They require proof that community bias is overwhelming.
With you over at LaSalle, go over all of the discovery that she's received, and we'll get a final decision on what do you want to do with your case at that next court date. Thank you. Thank you, Ms. DeLay. Thank you.
Thank you, Your Honor.
Thank you, Ms. Burge.
Yes, ma'am. Yes, ma'am. Thank you.
Ms. Burge, are you here on anything else?
Next door.
Okay.
Yes,
All right. Thank you. I was going to try to get you out of here if you needed something.
Yes, Judge.
Mr. Eckhart, you've got Alvin Wade.
Dude, Judge, he needs to be fingerprinted.
Okay. Did you already ask for him to be fingerprinted? Okay. We get Alvin Wade, if we can get him to Wade.
Wait. Okay.
Good morning.
Yeah, I'll be back.
Jack on.
Good morning. I think she's got another that she needs to want to.
That email done, exhibit 10.
Thank you very much. Look at that.
Judge, after Mr. Eckhart pointed out certain impediments to our prosecution, I have decided to waive both of those enhancement paragraphs.
Okay. Thank you very much. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Eckhart, will your client waive the formal reading of the indictment?
We do, Judge.
Mr. Wade, in cause number 25, DCCR 1648, the state's elected to proceed on count one only. It alleges that you committed a third-degree felony offense of possession of a prohibited substance in a correctional facility, and that is from July 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
But important moment here, the court swears in the translator. This protects the defendant's constitutional rights. If translation is inaccurate, the entire proceeding can be challenged. Due process isn't just about the verdict, it's about making sure every word in that courtroom is understood.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart?
Yes, sir. Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask that to everyone. Are you a U.S. citizen?
Yeah.
Yeah, okay. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Wade is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited substance in a correctional facility, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have
This is the critical plea colloquy. The judge is making a record ensuring the plea is voluntary, informed, not coerced. If that foundation isn't rock solid, the plea can be overturned later. Notice how methodical this process is. Every yes mommy's legally powerful.
questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams. All right, good luck to you, sir. Okay, are you Sally Pope, Israel? This is cause number 24 DCCR 21110. Ms. Pope is charged with assault on a public servant and was previously found not competent to stand trial. I'm going to take judicial notice of the court's file. Ms. Pope was sent to the John Dunn Behavioral Science Center for competency restoration. I've received the report from them dated February 4th of 2026. It looks like we've got the trial competency evaluation report, which was done by a Leah Emery, Dr. Leah Emery and Dr. Samantha Guzman. That's dated January 29th of 2026. And finding is that Ms. Pope is still not competent to stand trial and unlikely to be restored within the time frame of the 120 days that she had there at the John Dunn Behavioral Science Center, and that further inpatient treatment would be warranted. In addition, I have a forensic psychiatry report prepared again January 29th of 2026. This is from Dr. Selek, Selek, also with the finding that Ms. Pope is not competent to stand trial at the present time. Also, a physician's certificate of medical examination for mental illness prepared by Dr. Selek. And the finding in that is that okay, so his finding is that she is not competent to stand trial, that outpatient treatment would be warranted is what his position is, and that the patient's condition is expected to continue for more than 90 days. That Ms. Pope suffers from mental illness that is severe and persistent, that a result of that she needs treatment. And then I have a second physician certificate of medical examination for mental illness. This is from a Dr. Nubia Luberis, and the finding in this
2 years, that's the agreed sentence, and erase the key because it's a plea deal. The judge followed. The defendant waives most rights to appeal. That's the trade-off: certainty in sentencing versus the chance of fighting the case. Would you take a guaranteed 2 years or roll the dice at trial?
report is also that Ms. Pope is not competent to stand trial, that she is mentally ill, and this finding is also that she meets the criteria for outpatient treatment. And so, is there anything else with regard to competency from the state?
Not from the state, Judge.
Mr. Rojas?
No, you are.
So obviously, just for the record, everyone knows that we do not have an outpatient competency restoration program here in Jefferson County. And so I have no choice but to find that Ms. Pope is still not competent to stand trial. Find while the recommendation is outpatient treatment, because we do not have an outpatient treatment program for competency restoration, I'm going to order the 1 year civil commitment for Ms. Pope to the appropriate facility. Obviously, if competency restoration is attained before then, we'll get her back here. Otherwise, we'll await the report from whatever facility she goes to. All right, so we're going to try to get you some more help so that we can go forward with your
I
case.
go to Slidell in Louisiana.
I'm not sure it's not up to me where they send you. It's wherever the best place is. Okay. Okay. You can go back with the bailiff. Then Mr. Rojas, you've got Kaisha White. Well, no, because he's going to need it. I don't need to make all that. He's going to be, so if if it's actually picking text, he's like, so. Yeah, let's, just reset. Let's see. It's just one, right? We're going to reset Brenda Sanchez for Mr. Kimler. He's in trial over in drug court. He will be here at 1, Mr. Nichols, for our hearing, but we're going to reset his morning, and I think it's just Ms. Sanchez. Yes. Okay. All right. Are you Kaisha White? Yes. And this is 24 DCCR 2063. Ms. White is charged with assault on a peace officer. Mr. Rojas, what is the announcement?
Judge, we're actually here for a competency review, competency hearing this morning.
Oh, I'm sorry. Let me do
And
that.
then
Okay, let me take
also-
judicial notice. Let's do that. Or go ahead.
She
We've
pled
already played this case.
January 7th of 25. She didn't show up for sentencing.
Okay,
And when she was brought into custody, she was sent for competency.
okay. So
She's never been sentenced.
She's never been
Yes.
sentenced.
but did we get a PSI? Or
We did.
anything?
We did. She just didn't show up for the punishment hearing.
What date is it?
January 7th was the plea. She was set for sentencing February 24th of 25.
Oh, why this would have been standing in. It's okay. So let's do this. All right, so let me do this first and take judicial notice of the court's file. And Ms. White was previously found not competent to stand trial. No,
This is
she was, sorry,
found competent.
got it. Okay. She was evaluated for competency to stand trial. I've received that report from Dr. Rapon dated January 24th of 2026. The finding in that report is that Ms. White is competent to stand trial. Is there any other evidence with regard to competency?
There you are.
Not from the state.
Then at this time, based on that report, I will find that Ms. White is competent to stand trial. So have you spoken with Ms. White? Is it y'all's position to go forward with that?
I spoke with her about the PSI, about the previous plea, Your Honor, and she indicates to me this morning that she would like to go forward with probation. Is that right, Ms. White?
So when you were here last year, you entered a plea of guilty, and that was going to be with a deferred probation for 7 years was going to be the plea deal with a $500 fine and follow all of the rules and conditions of probation. So you've already done that plea. Do you want to go forward and get that probation today? Yes. Yes, the problem is it's been so long. I don't have those. How can we find the plea papers? So it'll be from last year though, from January 7th of 2025, right?
Yes.
But probation doesn't have. Somewhere there should be an old PSI that has their judges, their orders.
And that's what I just want to
I
go.
believe it's on the side of that PSI I just gave you, didn't it?
What the actual order says.
Oh.
Yeah, we get other.
Oh,
Okay. But if I do it today and we don't have those orders, is that something you can get with, to go back and get them to recreate? Because they've already been created. The date's obviously wrong, but they're somewhere. Somebody created them back then.
Yeah.
The, on Mr. Smith's PSI, it just has that short, the supervision plan, not the orders. So when we're done, he can get you a copy of that also to see what they had done at least back then. It just doesn't have all of the orders that you guys attached.
Okay, send it to you.
Thank you. They're almost exactly a year from the sentencing date. Okay, so any reason then not to go forward with sentencing? We need any type of updated pre-sentence report, or you guys think we can get it done?
I think we can do it today, Judge.
No evidence that either of you know of any arrests since last year? Who was arrested at Greenland? You were arrested in November before Christmas? You remember when you were? Yes. Do you remember when you were arrested? Yes.
Were you in jail for Christmas?
Mhm. All right, so what I'm going to do, Ms. White, I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to again find, based on Dr. Crapon's report, that you're competent and understand the nature and the consequences of that previous plea. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 7 years. You are ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That will include being on a special mental health caseload so that you can get whatever help you need in order to understand what's going on and be successful with probation. Okay? Do you understand?
Could you elaborate, Johanna?
Yeah. So tell me what you think and what you understand about the probation that you're going to get. Do you have a question about that specifically? So what's going to happen today is if I go forward and you get out of jail today, probation is going to give you some paperwork today. And you need to go straight to the probation office when you get out of jail. Do you understand that?
Yes.
Okay. When you get there, they're going to go over all of the rules and the conditions and everything that you need to do so that you don't end up back here in custody because you didn't follow a rule. Does that make sense? Because what happens is if you follow all of the rules that you're supposed to on probation, you go to whatever classes they tell you to go to, you get any counseling, treatment, whatever it is. If you do all of those things, then you will not have to go to prison. You'll be able to, this case will be over when the time frame is over and you won't have this conviction on your record. Do you understand that?
Yes.
If you don't follow all of the rules, and you don't show up maybe for an appointment, or you test positive for drugs, or whatever the rule is, if you break the rule with probation, you can be brought back here in court. You could be found guilty of the offense, and I could send you to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand that?
I understand.
Okay. And so, I'm going to hand you the trial court certification that shows this was an agreement and I followed it. So you can't change your mind later and appeal. And again, so probation will talk to you before you leave today. But Ms. White, it's very important. Ms. White, it's very important that as soon as you're released from jail, you go to the probation department so that you can get started on probation. Okay. So either today when you get out or first thing tomorrow morning, if you get out late, you have to go to the probation department. If you don't go, you're going to get arrested again and be back in court. Do you understand that? Okay. All right. Good luck. Thank you, Mr. Rojas. Thank you, Mr. Smith. And Mr. Smith, if you'll let probation look at that, please.